Welcome to the deep dive. Today we're exploring something pretty fundamental, an introduction to criminal law.
Yeah, getting into the basics.
Exactly. We're diving deep into source material made available for educational purposes by the University of London. Specifically, excerpts from their One Criminal Law Introduction.pdf.
It's great material.
It really is. Think of this as your essential guide, sort of, to understanding the foundations, designed to help you navigate the core concepts. This deep dive is brought to you by Sinorbit Academy, Sri Lanka. And look, we really wish you all the very best of luck with your exams.
Absolutely. Good luck, everyone.
Okay, so let's unpack this right from the start. The source material, it makes it really clear. Studying criminal law isn't just about, stuffing your head with rules and case names.
No, not at all.
There's something more required for real proficiency, something crucial they highlight immediately.
Well, what's fascinating here is how the document emphasizes skill development over just memorization. It tells us becoming a good criminal lawyer, or even just, really getting the subject, involves finding rules, applying rules, understanding procedure, evaluating evidence,
Right.
but maybe most importantly, having this critical and evaluative attitude. That's key.
That critical attitude point really does resonate. The source suggests true mastery comes from connecting the legal rules, the doctrine, to the bigger picture of criminal justice.
Yeah, the real-world application.
And the idea that simply applying a rule without thinking critically could, lead to a dangerous person walking free or maybe an innocent person getting convicted, it shows law isn't some perfect mechanical thing.
Precisely. And this raises a really important question. The source actively encourages you, the listener, to subject the rules you learn to critical scrutiny.
Just like lawyers do.
Exactly, just like lawyers constantly do in practice when they're arguing a case.
Yeah.
It's about thinking like a lawyer, really, from day one.
So you've got to ditch that rote learning mindset then. The source lists these core skills. Knowing the rules, sure, but also being able to find them, books, internet, whatever.
Yeah, research skills.
Understanding evidence, court procedure, and then applying those rules logically to a set of facts. These are the sort of fundamental building blocks, right?
They are, but building on those basics needs that critical dimension we mentioned. It's about appreciating how the rule, the process, the context, how they all interact to produce what the source calls a contingent outcome.
Contingent outcome, meaning justice isn't guaranteed.
Well, it depends on how the system works in practice.
Yeah.
You need to understand how the resources of the criminal law, as they put it, can be used to achieve substantive justice.
Which is underpinned by.
Ethical and political principles. It's law, definitely,
Yeah.
but it's also deeply about fairness and, society's values.
Okay. And the source gives us a pretty compelling example right away to show this need for critical thought. The case of Ireland. Let's make sure you've got that name. Ireland.
Yes, Ireland. A really important case to understand. The facts were, well, straightforwardly awful. A man made silent phone calls to a woman.
Just silent calls.
Silent calls, repeatedly. And it caused her clinical depression. Now, morally, obviously his actions were harmful, they were wrong.
Clearly.
But the challenge for criminal law, because of that absolutely fundamental principle of legality.
Ah, yes, legality.
Which basically says you can only be punished if your action is specifically prohibited by law at the time you did it. The question was, did his behavior actually amount to a criminal offense as the law stood then?
And he was charged with assault, occasioning actual bodily harm. So the prosecution was arguing that silent phone calls could be an assault if they caused fear of immediate violence.
Which is part of the definition of assault.
And that clinical depression counted as actual bodily harm. These are the two key concepts being tested.
Sure.
Assault and actual bodily harm, remember those.
And the case went all the way up to the House of Lords, which is the highest court then, and they upheld the conviction in Ireland.
Right. But here's where it gets, really interesting, and it links right back to that critical attitude. The source material explicitly asks you, the student, do you agree with this decision?
It's not just about knowing the result.
No, it's about evaluating the legal reasoning. As the source points out, okay, maybe it feels morally right to convict him because of the harm he caused, but you have to ask, does it strictly align with that principle of legality?
Was fair warning given?
Exactly. Was causing fear through phone calls truly an assault in the established legal sense? Is depression, a psychological injury, really bodily harm?
This is the absolute essence of the critical legal thinking that the source wants you to develop. It's grappling with those difficult questions where maybe your moral intuition clashes with the strict legal definitions.
So remember the Ireland case. Not just for the outcome, but for how it forces you to critically examine core concepts like assault and actual bodily harm and that principle of legality.
Definitely. Keep Ireland in mind.
Okay, so we've seen how you need to think about criminal law. Now, what exactly is it? The source moves on to define what criminal law actually comprises.
Right. So criminal law stands apart from civil law. Civil law is things like contract disputes or personal injury claims, what lawyers call tort.
Right, suing someone.
Yeah. The key difference the source highlights is the prospect of punishment. Criminal law involves the state stepping in.
Government, the police.
Exactly. When conduct has a sufficiently serious social impact. That's the phrase they use to warrant public action, not just a private lawsuit between individuals.
Okay, and the source gives us a really helpful list of the purposes of criminal law. It draws from the American Model Penal Code, but the ideas are fundamental. It's worth running through these core goals.
Yeah, good idea.
Okay, first, to forbid and prevent conduct that unjustifiably inflicts or threatens substantial harm to individuals or public interests.
Makes sense. Stop bad things happening.
Second, to subject people who are sort of disposed to commit crimes to public control.
Control and maybe rehabilitation.
Third, to safeguard conduct that is without fault from being condemned as criminal, protecting the innocent.
Crucial.
Fourth, to give fair warning about what conduct is actually considered an offense.
Back to that legality principle, fair warning.
And fifth, to differentiate clearly between serious and minor offenses, grading the severity.
Mm-hmm. These 5 propositions, they're like the mission statement for the whole criminal justice system.
But, and here's the critical thinking again, the source immediately prompts you to consider which of these purposes were potentially contradicted in that Ireland case we just discussed.
Ah, connecting it back. Good point.
Exactly. If we think back to Ireland, did the decision really uphold that goal of fair warning? Could someone making silent calls back then have reasonably foreseen they might be convicted of assault occasioning actual bodily harm?
It's a fair question. Was the law clear enough beforehand?
And did it potentially fail to safeguard conduct that is without fault, if maybe the legal definitions of assault and bodily harm were stretched beyond what people understood them to mean at the time?
It forces you to think about how those grand purposes actually play out in real difficult cases. So yeah, remember the Ireland case also when you're thinking about the purposes of criminal law.
Okay, so these purposes, they're put into practice by the whole machinery of criminal justice. The source then outlines the procedure involved.
Right, the process. This covers everything from, police preventing crime to actually bringing offenders to court and getting justice. And the procedures can vary depending on how serious the offense is.
They mention classifications like arrestable or non-arrestable offenses.
Yeah, which basically affects whether the police can arrest someone without needing a warrant first. It often relates to the seriousness.
And a really key player in this whole process is the Crown Prosecution Service, the CPS.
Oh, absolutely central. The CPS. They're the ones who decide whether to formally charge someone and bring a case to court.
So the police investigate, but the CPS decides whether to prosecute.
Broadly, yes. The police gather evidence, prepare a file, and then the CPS lawyers review it. The source explains their decision is based on 2 main things. First, the weight of the evidence. Is there a realistic prospect of getting a conviction?
Okay, the evidential test.
And second, the public interest test. Even if there's enough evidence, is a prosecution actually needed? Is it the right thing to do in the public interest?
So that introduces the idea of discretion. It's not automatic.
Exactly, a significant amount of discretion. And the source points out, again linking back, that the decision whether to prosecute in the Ireland case would have been a pretty difficult exercise of that CPS discretion.
I can imagine. So remember the Crown Prosecution Service, the CPS, and their crucial role involving discretion.
Mm-hmm.
The source also mentions something called undercharging. What's that about?
Right, undercharging. This is where the prosecution decides to charge someone with a lesser offense than perhaps the evidence suggests they actually committed.
Like charging simple theft instead of the more serious offense of robbery, maybe.
That's a perfect example. And the source gives reasons why the CPS might do this. It could be for evidential advantages. Maybe the elements of the lesser charge are just easier to prove beyond reasonable doubt.
Okay.
It can also encourage the defendant to plead guilty to that lesser charge, which avoids a trial.
Saves time and resources.
And it can also influence where the case is tried, which type of court.
Ah, the trial types.
Yeah.
Okay, the source distinguishes between a summary trial and a trial on indictment.
That's right. A summary trial happens in the magistrate's court. The key thing here is it's before magistrates, who are often lay people, or sometimes a district judge, but crucially, without a jury. These are generally for less serious offenses.
Okay, no jury in magistrate's court.
Then you have trial on indictment. This is for the more serious offenses, and it takes place in the Crown Court. And that involves a judge who deals with the law and a jury of 12 people who decide the facts.
Judge for law, jury for facts. Got it.
And then there's a big category of offenses called either way offenses.
Either way,
Meaning they can be tried either summarily in the magistrate's court or are on indictment in the Crown Court. For these either way offenses, the defendant generally has the right to choose to be tried by a jury in the Crown Court if they want to.
Ah, okay. They get a choice.
They do. Although in practice, the source notes that most criminal cases overall, including many either-way ones where the defendant doesn't opt for Crown Court, are actually dealt with by magistrates. So remember those trial categories: summarily, on indictment, and either way.
Right. Summarily, indictment, either way. And the formal document setting out the accusation, it's called an information in the magistrate's court.
Correct, an information for summary trials.
And an indictment in the Crown Court.
Yes, an indictment for trials on indictment. The source even shows us what a potential indictment for the Ireland case might have looked like.
Oh, yeah.
Yeah, it sets out the statement of offense, assault occasioning actual bodily harm, and then the particulars of offense. John Ireland, on specific dates, assaulted Vicky Henderson, thereby occasioning her actual bodily harm.
See what it is again. The case name, Ireland, and the core offense, assault, occasioning actual bodily harm. Repetition helps.
It really does.
Yeah.
Now, in a Crown Court trial with a jury, we said the judge and jury have distinct roles. Judge handles the law.
Okay.
So, going back to Ireland again, that key legal question was whether psychiatric injury, like clinical depression, actually counted as actual bodily harm under the relevant statute.
Right. The defense lawyer argued it didn't. That was the point of law.
Correct. It was up to the trial judge to make a ruling on that specific legal point. And the judge in Ireland's trial ruled that, yes, it did count as actual bodily harm.
And what happened then?
Well, once the judge made that crucial ruling on the law, Ireland actually pleaded guilty. So the jury wasn't needed to decide the facts, like whether he made the calls or if she suffered depression, because he admitted those things happened by pleading guilty.
Ah, okay. So the judge's ruling on the law was key.
Absolutely. And that ruling on a point of law can be appealed.
Right. The appeal passed. Where do appeals go?
From the Crown Court. Appeals on points of law generally go to the Court of Appeal, Criminal Division. And from there, potentially, on a point of law of general public importance, up to the Supreme Court.
And Ireland did appeal.
Yes, Ireland appealed the trial judge's ruling that depression was actual bodily harm. He argued the judge got the law wrong on that point. But, as we know, his appeal was ultimately unsuccessful. The higher courts agreed with the trial judge.
Okay, so remember that appeal route and how Ireland illustrates appealing a specific point of law decided by the judge.
Definitely. Now, the jury, they're the judges of fact. They listen to all the evidence presented by the prosecution and the defense witnesses, documents, whatever it is, and they decide what they believe actually happened, whose evidence they accept.
But they're not just left completely on their own to figure it out, are they?
No, not at all. The judge supervises the jury's role. The judge makes sure the jury only hears relevant and admissible evidence. And critically, the judge gives the jury directions at the end of the case before they go off to deliberate.
Directions on what?
Directions on the law. The judge explains the relevant legal rules the jury must apply to the facts as they find them. And a fundamental part of those directions is explaining the burden and standard of proof.
Okay, burden and standard of proof. Crucial concepts.
Absolutely crucial. Always remember, the burden of proof in criminal cases is always on the prosecution. The defense doesn't have to prove innocence. The prosecution has to prove guilt.
Innocent until proven guilty.
That's the principle. And the standard of proof they have to meet is very high. They must prove the defendant's guilt beyond reasonable doubt. Not just probably guilty, but beyond reasonable doubt.
A very high bar.
It is. And if the judge makes a mistake in explaining the law or the burden and standard of proof in these directions, that's called a misdirection. It can be grounds for the defendant to appeal their conviction.
Right. So key concepts there. Burden of proof is on the prosecution. The standard of proof is beyond reasonable doubt. And the judge gives the jury directions on the law.
Got it. Those are fundamental.
So we've talked about the rules and procedures. But where do these rules the judges explain and apply actually come from? The source tackles the sources of criminal law next.
Yeah, where does it all originate? Historically, a lot of English criminal law was common law.
Meaning judge-made law.
Exactly. Developed over centuries through judicial decisions and individual cases. Really serious offenses like murder and manslaughter originally came from the common law, not from Parliament writing a statute.
But that's changed now, hasn't it?
To a large extent, yes. Today, most criminal offenses are created by Parliament through acts of Parliament, which we call statutes.
Okay.
Parliament can create entirely new offenses this way, or sometimes it takes existing common law offenses and puts them into statutory form, codifies them like the law of theft or many assault offenses.
This is mostly statutes now.
Mostly, yes. But, and this is important, even when an offense is in a statute, common law principles and judicial interpretation often still play a huge role in defining its precise scope and meaning.
Like in Ireland.
Exactly like Ireland. He was charged under a statute, the Offences Against the Person Act, 1861, a really old one. But the critical question of whether psychiatric injury counted as actual bodily harm under that statute wasn't explicitly answered in the act itself. That was decided by judges interpreting the statute, drawing on how the concept of harm had developed through common law decisions over time.
So common law interpretation is still vital, even for statutes.
Very much so. The source also highlights other significant influences. European law used to be more relevant for the UK before Brexit, but crucially, there's the European Convention on Human Rights, the ECHR.
Right, the ECHR, still very important.
Absolutely. The ECHR remains a vital source of challenge to domestic criminal law. The Human Rights Act incorporates convention rights into UK law. The source gives two really powerful examples of this, cases decided by the European Court of Human Rights in Strasbourg.
Okay, what are they?
First, Dudgeon in UK. This case involved a law in Northern Ireland which, at the time, criminalized consensual homosexual acts between adult men, even in private. The European Court found that this law violated Article 8 of the ECHR, which protects the right to respect for private and family life. It was a landmark decision.
Okay, so Dudgeon v. UK, Article 8, private life,
Okay.
and the second case.
The second is AV UK. This involved a boy who was beaten quite severely by his stepfather with a cane. The stepfather was prosecuted but acquitted in the UK courts because of a common law defense allowing reasonable chastisement of children.
Reasonable chastisement.
Yes. The case went to Strasbourg, and the European Court of Human Rights found that allowing this defense and the UK law permitting such physical punishment was inconsistent with Article 3 of the ECHR.
Article 3 being?
Article 3 prohibits torture and inhuman or degrading treatment or punishment. The court said the beating went beyond reasonable chastisement and breached the child Article 3 rights.
Wow, so those are strong examples. Remember Dudgeon v. UK, Article 8, and AV UK, Article 3, as key illustrations of the ECHR's impact on domestic criminal law.
Definitely. And the source notes that in both cases, Parliament acted pretty quickly afterwards to change the domestic law and bring it into line with the convention rulings.
Okay. The source also briefly mentions the UK leaving the EU. It says it won't have an immediate effect on the core criminal law covered in the course.
Right, because most of that is domestic statute or common law, or influenced by the ECHR, which isn't an EU institution.
But maybe long-term compatibility questions with EU law might fade, while the ECHR's influence through the Human Rights Act remains significant.
That seems a reasonable assessment. Now, finally, the source provides some absolutely crucial guidance on study materials and how to approach learning.
Right, the practical stuff, how to actually succeed.
Exactly. And success in this subject really relies heavily on using the recommended resources effectively. The source is very clear. The core textbook is Wilson, W. Criminal Law. They mention the 7th edition was current when the guide was written, but obviously you'd use the latest available edition.
So Wilson is essential reading.
Essential. The guide is designed to be used with it. Reading the guide alone, the source warns, is simply not enough, and they strongly advise checking the examiner's reports.
Ah, the reports from past exams.
Yes. They often explain why students who didn't engage properly with the textbook and the cases struggled. So, use Wilson.
And they also recommend getting a criminal law casebook.
Yes, strongly recommend it. They suggest Dine, Gobert, and Wilson cases and materials on criminal law. Again, check for the latest edition. The 6th was mentioned as one that aligns well with the Wilson textbook. Reading the actual case judgments or good extracts is vital.
And they say reading other textbooks is good too.
Encouraged, yes. For different perspectives or deeper dives, they list several good ones. Ormerod and Laird, Porter, Kidd, Eliot, and Walters, and Herring mentioning his main textbook and also his Great Debates book for more analytical stuff. Again, always aim for the latest editions.
And crucially, you need a statute book for the exam, right?
Yes, an unannotated criminal law statute book. Unannotated means no notes written in it. You're usually allowed to take that into the exam hall. Check the specific regulations, but it's standard practice.
Don't forget the online resources either. The
Yeah.
VLE, the virtual learning environment.
Oh, absolutely key. And the online library. The source highlights both. The online library is described as being like having a fantastic, well-stocked law library right at your fingertips.
Perfect for reading those key cases they keep talking about.
Exactly. Reading cases is how you really grasp legal reasoning, how judges analyze problems and apply the law. It's a core legal skill.
And the criminal law section of the VLE itself sounds like a treasure trove. The full module guide, feedback on activities, assessments, newsletters, updates, links, discussion boards,
Past papers, examiners' reports.
and audio lectures and presentation slides that actually match the guide and the textbook. That
Oh.
sounds brilliant for learning, checking understanding, and revision later on.
It really is invaluable. Use the VLE regularly. Now, preparing for the actual examination, the source says it requires a systematic approach.
How so?
Work through the guide chapter by chapter. Actively do the questions and activities provided. Don't just read them, try to answer them, using your textbook, your casebook, other materials.
Engage with it.
Exactly. The source stresses this point. You are examined primarily on your skills as a lawyer, your ability to analyze problems, apply the law logically, construct arguments, think critically, not just on how much information you've memorized.
So the activities are crucial for developing those skills.
Crucial. Use the "Am I ready to move on?" checklists at the end of chapters. Use the advice on how to answer problem questions and essay questions that you'll find in the guide and on the VLE. And always, always check the VLE for the most up-to-date information about the exam format and any changes. Don't rely on old information.
That's really practical advice. And look, starting law, especially if English law is a new system for you, it can feel a bit daunting, maybe overwhelming at first.
It can seem like a different language sometimes.
Yeah. But the source offers some reassurance. It says, it's just like any other academic subject in the end. You build your understanding step by step. And encouragingly, it points out that criminal law is actually full of really interesting cases and fascinating ideas.
It is. Human drama, ethical dilemmas.
Absolutely. The source hopes you'll find it enjoyable as well as interesting, because they say when you start finding it genuinely engaging, that's often a sign you're well on your way to success.
A good motivator.
Definitely. So we've taken quite a deep dive there into this crucial introductory material. We've covered the lawyer's method, the need for critical thinking, using that Ireland case as a prime example.
Ireland came up a lot.
It did. We looked at what criminal law is, its core purposes, again linking back to challenges raised by cases like Ireland. We explored the procedural side, the CPS, trial types like summary, indictment, either way, the judge and jury roles, burden, and standard of proof.
Don't forget the sources, common law, statute law, and the big impact of the ECHR, with cases like Dudgeon v. UK and AV UK.
Right. And finally, that essential guidance on study materials using Wilson, casebooks, the VLE, the online library, and focusing on developing skills through the activities, always checking for exam updates.
So remember those key concepts and names we kept mentioning. The principle of legality, assault, actual bodily harm, especially as debated in Ireland, the Crown Prosecution Service, or CPS, the trial categories, summary, indictment, either way. Burden of proof always on the prosecution. Standard of proof is beyond reasonable doubt. And the influence of the European Convention on Human Rights, the ECHR, shown by Dudgeon v. UK on Article 8 and AV UK on Article 3.
Keep going back to Ireland in your mind. As you said, it connects so many of these fundamental points.
It really does.
Well, this deep dive was based on materials made available for educational purposes by the University of London and brought to you by Sinorbit Academy, Sri Lanka.
And just to echo what the source material itself says, good luck for your exam. Seriously, work hard, use the resources, and you'll do well.
And maybe one final thought to leave you with, drawn directly from the source material itself. Criminal law, it says, is underpinned by ethical and political principles. The aim is to ensure both justice for the individual and protection for the community.
Often a balancing act.
Exactly. So the question to ponder as you study is, how do we make sure that in practice, applying these legal rules truly serves both of those aims, especially when they might seem to conflict?
A deep question to keep considering.
It is. Something to think about as you delve further into the fascinating world of criminal law.
Indeed.
So that's it for this deep dive. We really hope it has given you a solid foundation and some useful insights as you begin your studies.